Okay, Shannon, you could put us on the record. Good afternoon, gentlemen. Sorry for the delay. We were having some technical issues at this end, but it looks like they're all resolved.
Well, I understand that, gentlemen.
So I think we're ready, Mr. Miller, for your cross-examination of Mr. Vollwinkle.
Yes, sir. Good morning, Mr.
Mr.
Boyd.
Mr. Vollwinkle, you understand that you're still under oath?
Yes, sir, I do.
Go ahead, Mr. Miller.
All right, well, while you're under oath, I just want to start with one thing we do have in common is that we both enjoyed last Saturday as a Spartan, correct?
No, that is correct. And I will say that I did enjoy that under oath.
I didn't think that would be a problem. All right, I want to jump into management fees. You indicated in testimony yesterday from your attorney's questioning what you felt maybe was fair. But the fact is that you owed, according to the agreements among shareholders, you owed management fees for the second quarter, or you still owe them. Is that correct?
I never disputed that I owed management fees.
And we went through this at your deposition, and you remember at your deposition where you said that you estimated it was $90,000 or $100,000 that you owed?
No, I didn't say that I owed that. I said that I had estimated that was the amount of management fees being charged or invoiced to me was around $100,000.
Okay.
I didn't say that I owed that.
Okay, well, let me just look at your deposition here. It's your deposition. I think it's going to be page 56. It's exhibit 35. And can you see, is that on the screen? I just always have to verify after my complication. Can you see the highlighted deposition transcript?
I can see it just fine.
Yes, okay. So this is page 56. And I asked you a question that this is management fees. Your invoice fees, like all the five were for the second quarter of 16. You said, and you testified you didn't pay them. I'm just wondering if you could tell me what the value, an estimate of the amount that you were invoiced for, and you said it was probably 90. So maybe this is going to affirm you. And then I said, okay, you said somewhere 9, maybe 100. And I said, is it your testimony today that you don't owe them? And you said, I never said that I do not owe those management fees. So are you saying today you don't owe them?
No, and I think that is slightly pulling out of context my deposition. So I had just mentioned to you before you showed me the exhibit that I was invoiced for management fees of $100,303 and change. And I said to you that I acknowledged that I was invoiced that amount, and I never challenged that I didn't owe management fees. When you say those, that's a single, the management fees I was referring to were, let me start back over. I didn't challenge that I had owed management fees. And in my deposition, I said the same thing. I was invoiced amount, and I didn't challenge that I had owed some management fees to the Michigan Pipe Company. I never once did. So
immediately after you indicated that you were invoiced for $100,000, and I said, is it your position you don't owe those? And your response to me, I never said I didn't owe them.
Objection, Your Honor. He's arguing with the witness. This is asked and answered.
Well, he's an adverse witness, and okay, go ahead, Your Honor. I'll wait.
I think perhaps you should give the witness the opportunity to look at his full response, and particularly page 57.
Okay.
So this would coincide with the rest of the context of my answer that I just provided to you, where I've never challenged that I don't owe some sort of management fee for the services performed by Michigan Pipe Company as it related to my sales. I just challenged the amount that was owed to me.
You testified yesterday that you didn't feel you got value because you used two quarters, the first 2 quarters, and you based the assumption then that the management fees you were paying were, at least that you were invoiced for, I believe your testimony, that you felt it was excessive. Is that a fair assessment?
So
It's a yes or no.
remembering yesterday, it's based on the operating expenses of Pipeco. So based on the operating expense deficit for Pipeco, I felt that I was overcharged for the services rendered for me.
And you used 2 quarters to make that determination. You didn't look at the costs over a whole year, because the cost of a company like Pipeco, or any company really, you have to look at a 12-month cost to find out what the really charges are. But I'm gonna take you back to an exhibit that you've seen many times, and it's this exhibit. This is a management fee estimate. This has been shown a couple times. Are you familiar with this document, this exhibit?
Yes, I am.
Okay, up in the upper left-hand corner, we see that there's a graduation that the companies, or that the more you make, you start paying less management fee. Is that correct?
That's correct. Not the more you make.
The more you sell. Is that sales then?
Yeah, yeah. Because
Okay,
remember, management fees are based on a percentage of sales. So the more I would sell, the less I would pay for this particular slide.
Thank you, Mr. Blanco. That I stand corrected, because that is what I intended to say, and I didn't. So now this sliding scale came into being in, I think, 2013.
Okay.
I'm asking you. That's really a question. Do you remember when it came into being?
I cannot say under oath exactly when that came to be.
Can you give me your best estimate?
Yeah, I would say approximately 2012 or 2013.
Okay.
The discussions were had.
And at this time, you were the operations manager in Lansing, were you not?
Correct, I was.
And this was actually proposed by you because you saw that Lansing was kind of paying too much. Is that a fair statement?
I think it's a statement taken out of context, but
Okay, we'll put it into context. Let me just ask a question at a time then, and I appreciate it. Was this proposed, this sliding scale, by you?
yes, it was.
Okay. And was it presented then to all the board members?
At some point, yes, it was.
And all the board members, including the board member representing Lansing, approved the sliding scale, correct?
Yes, they did.
Okay. So from that point on, all the 5 entities were charged according to that sliding scale. For example, in quarter 1, we have all these. Flint had 21,608. Jackson had 9,518. Lansing had 22,530. These were all paid, and these were all based on the sales. Now I'm going to go up. This was actually page 2 of this exhibit. You go up to page 1, it has your sales, and so it's simply math. You take these sales and you multiply them by that percentage. Is that correct?
That's correct.
Okay. So this was in fact an agreement among the shareholders to charge each individual entity management fees for the purpose of running the home office. Is that correct?
Partially.
How is it not correct?
There are correct statements to it, but there's an expansion of that, meaning we still knew, per these discussions, that this was going to give us an excess dollar amount in Pipeco at the end of the year. And it was discussed prior to just coming up with a slide based on our scales. Prior to a scale based on our sales. The discussion was companies were expending a lot of cash to Michigan Pipe Company on a monthly basis for the management fees and it was always in excess of what it needed to be for them to provide their services to us. So as a result, we figured if we could keep cash in the stores or in our entities, it would better our bottom line by being able to pay our bills at an easier rate. So the context of this scale isn't simply because this is how we determined that Michigan Pipe Company would break even at the end of the year. This was just simply to reduce the amount of excess cash on a monthly basis or quarterly basis to Michigan Pipe Company throughout the year. It became a lot easier for the office staff to calculate overages of $60,000, $70,000, $80,000 versus trying to figure out where $200,000 would go on, as you heard Linda speak yesterday, December 31st of every year.
Is it your testimony that in 2014 there were refunds of management fees? Because my information was that 2014 you didn't have refunds. So is it your testimony under oath today that 2014, a year or two after this was implemented, that you had management fee refunds?
I believe that in 2014, and I can't say 100% on the date, that there was a refund given back from Pipeco.
But it will give you that at the beginning of the year, or when the owners or the board members of Michigan Pipeco, they have to come up with a way to make sure they can pay their bills. With everything's in context, Mr. Bowinkle, but the purpose of this management fee was so that you could pay the bills of the corporate. The corporate had their own employees, they had to rent space, they had their own expenses. And that's what the management fees were intended to do. Is that correct?
That's exactly right, to pay for the operating expenses of Pipeco.
And so it was by design, and I think that I'm agreeing with you, but it's by design you wanted to be a little high if you could. You'd rather have to be a little high than a little short. And then at the end of the year, it was money in the pool of Michigan Pipeco. And the design was Michigan Pipeco existed for the benefit of the shareholders, not the other way around. Is that true?
I don't believe so.
Okay. At the end of the year, I'll start out and ask one thing at a time. I do tend to ask multiple things. At the end of the year, there would be, by design, a little surplus in the management fee left in Michigan Pipeco. If everyone paid their management fee, it was by design there would be a little excess at the end of the year. Is that correct?
No, by design, the amount that was determined to be paid into Pipeco would cover the management fees. By our sales performance, it proved to always have excess money. By design, the 1.34% initially determined covered Michigan Pipeco's expenses. There were no by design to have excess money. It just worked out that way based on sales.
Okay, good. So this was an agreement that you all had with one another and the company, essentially, that you would pay this kind of money based on sales so that the Michigan Pipeco would have funds to operate. Correct? Yes or no?
That statement's correct.
Okay. Then, are you familiar with the bookkeeping systems of Michigan Pipeco?
I'm aware of them. I'm not familiar with them.
Well, we're going to have CPA Tina Heath testifying probably this afternoon. But what happened is the company, in a sense, that these management fees were treated by Michigan Pipeco as an accounts receivable. So in a sense, it treated its shareholders as customers. And so when these management fees became due, Michigan Pipeco treated it as a accounts receivable. Is that correct? Or do you know enough to be able to answer that?
It would be listed under the accounts receivable, correct?
Okay.
Would Pipeco then present a credit to the form of a customer at the end of the year?
Well, at the end of the year, then the board would get together and deal with that. But I want to go in a different direction. There are basically two aspects to accounts receivable. And one was the management fee that everyone agreed to. And so if there was a contract in this scenario, this is an example of a contract because there was a meeting of the minds by everyone involved, your proposal, and everyone agreed. And it became an account. When you had sales on a quarterly basis, it became a receivable of the company. Now, there's another way that there's receivables because I believe that you testified that, or someone has testified that Michigan Pipe Co. was also an employee leasing company. Is that correct?
Yes, Michigan Pipe Co. is an employee leasing company.
Michigan Pipe Co. is a leasing company, yeah. Is that a correct statement?
Yeah, that's right.
I'll get out of this for now so I can see you. It's much better. So, and what really happened, and this goes to the fact that you refer to it sometimes as bookkeeping, that you felt that it was better to have it do all centralize everyone's payroll, everyone's Blue Cross Blue Shield, everyone's unemployment at a central location. So all of your employees, they were your employees and reported to you, but they were processed through Michigan Pipe Co. Is that true?
Right. My employees reported to me, but their salaries and fringes were reported through Pipe Co. Correct.
Okay. So when Michigan Pipe Co. spent money on employees of one of its shareholders, and in your case it would be Lansing, then that became another accounts receivable that Lansing had to reimburse Michigan Pipe Co. for the actual employee costs that were being incurred. Correct?
Correct.
Okay. So now I want to show you, and you've seen this because we've been discussing it already in this trial. I want to show you exhibit 50, the age receivable. Let me just confirm what exhibit that is.
It says on the top tab there.
It's 13. I get the one we were referring to as 15. This is 13. So, have you seen this accounts receivable document before today?
Yes, I am.
And are you familiar with Peachtree? I think is what your accounting system at Michigan Pipe Co. is.
Again, recognize it. I wouldn't say I'm familiar with the actual software program itself, but recognize the statement.
Okay. This looks like a typical printout from the accounting software at Michigan Pipe Co. Then is that a fair statement?
That's correct.
Okay. And you see where we have Michigan. Well, I better get it over to that. We have Michigan Pipe and Valve F. And do you understand that to mean Flint?
I do.
Is that yes?
Yes, I do.
And then we scroll down and we went through this with Linda Prater. Were you present during the testimony of Linda Prater?
Yes, I am. I have. Yes, I was.
Okay, so this is then MPV Lansing would be the accounts receivable for Lansing. Is that correct?
That is correct.
Okay. And I just want to tie things in. So the two aspects of this are the second quarter management fees that we just went through from Exhibit 50.
Okay.
The invoice, and this shows the accounts receivable that we talked about at $100,308. True?
Right.
And this is not a surprise because you've just testified that it would in fact appear on the books as an accounts receivable, and there it is. The other items that would be accounts receivable, Guardian and BCN and BSBC, those are employee related. Now, the testimony has been, and I think from Linda Prater, that there's so many negatives is because this report is December of 16. So there were payments made, but then when the employees all left, because it wasn't just Michigan Pipe and Valve Lansing that left, all Michigan Pipe and Valve Lansing employees left as well, correct?
Correct.
So there were, how these employment things issue there, you have to pay, then you get a credit. So this reflects a lot of that activity. But in looking at this, do you have a dispute with, other than the that we've already talked about regarding the management fee. Do you have a dispute? Does anything strike you here as being improper?
Well, not getting any of the background on things dated 7/16, I see some of them did have credits, but I also see, costs associated with the insurance policy from Richmond Agency of $6,000 that didn't appear to have any sort of credit for that payment. I do recognize the safe harbor payment of $9,500. And I see, there are a lot of pluses and some minuses, correct?
Okay, and okay. So between all the pluses and minuses, we have of that 103 is the management fees, and then we have roughly 14. I'm really rounding up or down, but roughly 14 of other employee-related costs that appear on this. Is that correct?
Correct. And of that, we would have, two positives that would stand out just looking at this right now. Second quarter safe harbor, which was 401k contributions to my employees and myself. And then also, again, the Richmond Agency, which was the umbrella policy for the entities of a June 16th entry of $6,190 that was probably supposed to cover the second half of the year or the month, however it was stated.
Where is, and excuse me, you mentioned the 401k deposit. Where is that 401k deposit on here?
Second quarter, SH.
$9,599.51. 2016 second quarter SH safe harbor.
Okay, and then is it your testimony that wasn't paid? I see it right here. Is it your testimony that wasn't paid or was paid?
Well, it's my testimony that it was not paid. I said there are two positives on there, that we have the second quarter safe harbor of $9,599.51, and we have a Richmond Agency of $6,000 and change.
So that was for the second quarter, and so it's your testimony that the Michigan Pipe Co did not pay the second quarter 401k money. So that's a very significant thing. If they
say that again,
because this says it's for the second quarter for the employee safe harbor 401k. It's a very substantial IRS issue if they didn't make that payment. So is it your testimony that they didn't make the payment, or you don't know if they made the payment?
No, I don't know if Michigan Pipe Company made the payment for the second quarter safe harbor.
Okay. I'm gonna represent. Well, not gonna represent anything. So this is on accounts receivable. In your experience with accounts receivable, it doesn't appear on here unless there's a payment made. Is that your understanding of this aged accounts receivable document?
If a payment is made or received, yes, it would show on the accounts receivable.
Okay. All right. So is the reason you didn't pay, let me just ask it directly. What is the reason you didn't pay your accounts receivable? They invoiced you for those things. And so what's the reason you didn't pay?
The reason I did not pay my accounts receivable, the reason I didn't pay the full management fee was I had a discrepancy with the total management fee that was requested of me. And the other factor being they had expressed giving me my rebate money back, but they said, we're not going to we're going to get your rebate money back to you. And I said, then my accounts receivable will be covered. And why would I give you another $100,000 when you still haven't given me back the money that you've been promising me to give me back?
Okay, that's fair. But you were that's kind of a logical thing, but you were basically saying, why am I going to pay you money when you owe me more money? Is that a shortcut way of saying what you just said?
I believe what was stated was, if that accounts receivable is owed, pay the accounts receivable out of the rebate money.
Yeah. Okay. So you were wanting to have it be a set off. Now, in that regard, you
Again, just
testified
clarify.
that you had. Excuse me. Let me ask this question. You testified, or like Mike Deneen did, and I believe you did yesterday too, that you received a take or leave it offer in December. Remember that testimony?
Yes, I did.
You never mentioned any other negotiations or offers. There were other negotiations and or offers, correct?
To give you the timeline you're referencing.
Well, between December and you filing a lawsuit on April 27th, 2017.
Yes, there was an amended offer.
Yeah, and that came to your attorney on April 6th, correct? Have you seen that offer?
Yes, we did.
I think I got a copy of it here. Let me see if I can pull it up.
Is it an exhibit that we need to reference?
No, I didn't anticipate using this.
Okay, just checking.
So this is, I guess, what's the next? I might as well give it a number. What's the next exhibit in order? Is it 40? Anybody know?
It would be 40.
Okay, so I'm going to mark this 40. And this is a letter that was sent to your attorney on April 6th. I don't know when exactly your attorney saw this, but do you remember seeing this letter?
Yes, I remember seeing the letter.
Okay. So this letter offered a little more money. They probably got more, a better accounting from the embassy. And so it's not true that there was a take or leave it in December. We were trying, Michigan Pipe Co. was trying to pay you more money and resolve this. And what was your response to this letter?
And it still seemed lower than what was anticipated.
Okay, and so did you counter then?
I can't speak under oath at the timeline for which a counter or following a number followed.
Okay. Is it your testimony that a number followed before a lawsuit was filed?
Again, putting a date constraint on my reply versus the lawsuit being, I cannot say that under oath that it happened sequentially.
That letter is dated April 6th, and the lawsuit was the response. I'm going to suggest to you that the response was a lawsuit being filed. And that's why it's interesting, because from my perspective, your response to this increased offer was a lawsuit. And it's important for you to know, or I think it's important to understand the nature, since I believe your attorney was trying to create a good guy, bad guy thing, is that my client was trying to figure out how much you owed and was making good faith offers. Now, you may have disagreed with it, but you argue that this is not a good faith offer on
I do
April 6th?
argue that it's not a good faith offer. Offer. I will argue that, yes.
Okay. And why is this not a good faith offer?
Because the offer fails to quantify all of the money that had been earned by both of our locations through our efforts as it pertained to Michigan Pipe and Valve.
So you disagree. You disagree with the amount of the offer, even though they did give you the formula here, and you're using the formula, some of these numbers on your spreadsheet, but you just. Let me back this shit up.
Objection to the incorrect statement. That doesn't, the record won't reflect that they gave you the correct information ahead of time.
I have no idea how to respond because I don't understand the objection. But
The
I'm not
objection
sure
is,
I do either.
if I could clarify, Judge, the objection is he's stating something that wasn't on the record. He says that Mr. Deneen was provided with the information to the formula to compute these numbers, and that's not accurate, and it's not in the record.
You mean Mr. Bowen?
It's cross-examination. If the witness disagrees with the form of the question, he could certainly say so.
Thank you, Judge.
Well, just for the sake of being complete here, this letter actually has attachments, and I need to ask Mr. Brinkle, were you aware that these attachments were on this offer? Did you see these attachments?
Yes, I did.
Yeah, okay. Then there's another one that has a sheet similar to the one we've been talking about.
Correct.
All right. I would ask that this be admitted into evidence.
No objection, Your Honor.
At the time that we received that offer letter,
Hold on.
Sorry.
It's not a question, Ken.
There being no objection, 40 is admitted.
Okay, thank you, Your Honor.
sorry, Your Honor.
Okay.
I
I just
at the
let me ask a question. Mr. Goenkel. Your counsel will have ample time to kind of redirect if something that I said is wrong or he needs to clarify. But you heard the testimony, and I think you even provided some, that the embassy group provided information in a different way than the vendors used to prior to embassy. Is that a fair statement?
it's a fair statement.
So Linda Prater was having a heck of a time trying to get the proper information in order to come up with a accurate breakdown of the rebates. You remember that? Did you hear that testimony from her?
Yes, she did say that it did prove difficult from some of the vendors to get accurate breakdowns. Correct.
And so she had other options, like using accounts payable, or there was another option. But Linda Prater, being an exact person, testified that the only real exact way is to go back to the vendors. And do you agree with that?
Yes, she did state that.
Well, do you agree with it?
Well, I certainly agree with it. The vendor breakdown was going to be the more accurate way of reflecting.
Okay. And that's because everyone agrees that rebates are based on purchases, not sales or not anything else, but rebates are based on purchases of pipe from various vendors, correct?
Yes, they are.
And I think you testified too that you would make a purchase, and then when it was paid, that at that point in time, you felt you had a right to a rebate.
That's correct.
Correct?
I said that's correct. Yes.
Okay. I'm having a little trouble always hearing the correct, so forgive me. When before embassy, you would have the hands-on communication with the pipe vendors, and so the pipe vendors would basically send you a sheet describing their particular rebate plan and how to break it up according to their purchases. That was historically what happened. It's not 100% of the time, but historically, that is what typically happened. Is that a fair statement?
That was one of the avenues that we determined rebates from. Correct.
And after embassy, what happened is that embassy would write a check, and they would let you know what vendors is involved, but they wouldn't let you know how the breakup was among the various shareholders of Michigan Pipe Co. Is that correct?
That is correct.
That's what created the problem for Linda, because she didn't have the data from embassy to properly determine how to divvy the rebates up that Michigan Pipe Co. received. Remember that testimony?
Yes, she didn't have the complete accumulation of data. Some were received, some weren't. But yes, she didn't have the complete accumulation of data to provide what she wanted to be a very accurate rebate return for everybody. Correct.
Isn't it true that everyone wanted accuracy if they could have it?
I think that it behooved all of us to make sure that, we would try to be as fair as we could be with, in regard to rebates.
Okay, so we're on the same page, believe it or not, with that. So a committee was formed in April of 2015. I could show it, but if you recall me providing Exhibit 6, where you, Mike, and Linda formed a little committee to go out and come up with some way to divvy up, I think is what the board members actually said, the rebates, and then report back to the board. Do you remember that committee being assigned in April of 15?
Based on the meeting minutes, yeah, I remember that committee. I don't specifically remember the conversation as it happened live, but the meeting minutes would suggest that.
Okay. And you have no reason to doubt that those minutes are not accurate, do you?
Oh, correct. Yeah. I'm just saying for the record, I don't remember the live action, but I do recall based on the minutes.
Okay, that's fair. And Linda's testimony was essentially that the committee really never met as a committee, and you really never came up with any method to present to the board. You remember?
I think that's taken out of context for what she actually said, but
okay. I'm going to ask you: did you guys come up with a plan to give to the board?
There was not a plan that was written and inserted into subsequent meeting minutes. No, that doesn't mean we didn't have a vocalized plan as to what our process moving forward was going to be.
Well, you had options in how to do this, right? You had the AP method that she mentioned. You had the go back to the vendors and do that laborious task of finding out what the vendors did. You could do it based on sales, I think was one mentioned. You had options that you discussed. Is that what you're referring to?
Yeah, we had options. Everybody, all the owners knew how to calculate rebates and how the rebates were to come back to them. So when we had options to present rebates back to somebody, the unfair thing to do would say, well, we should just base all the rebates on a percentage of sales if we can't get a breakdown, right? Because that provides me with the largest rebate of the group, which is, not a very fiscally responsible thing to do for the board. The other option is to go by payables. We decided as a group, let's try to figure out a way that it doesn't take us hours and hours and hours. And so if we started with 3 different methods of calculating rebates, I figured one to be unfair right from the get-go because that it strictly benefited the largest sales guy, and that's not right for anybody else. The second option was, as a group, determined per the meeting minutes, determined that we didn't want to spend that time to try to calculate them that way. So we were then waiting for vendor breakdowns so that we could get what we determined, even before the committee responded, to be the best means and methods of getting everybody their money back.
Now, in the discovery, you've been pretty active in this case. Have you reviewed the discovery documents? I believe that roughly between 800 and 900 pages of documents have been provided, which really represent everything that Mr. Petco had regarding rebates. But there was a number of emails in there between Justin and the various vendors. Did you? First of all, let me back up. Have you reviewed those documents?
I have reviewed the documents that were sent over by your office for us to review. I have.
Okay. And so you saw evidence in there that Justin Jaime was attempting to go and do the vendor breakdown method that Linda Prater preferred, and by emailing all and every single vendor to try to get their breakdown of the 2016 rebates. You saw evidence of that then if you reviewed those emails.
Yeah, I believe that the email exchanges were part of the exhibit submitted.
Okay. So now, if in fact there was a summary of rebates of what everyone was entitled to get that was based on the vendor breakdowns, that would be the superior summary to one that was just based on AP or sales, correct?
Just so I catch it clear, you're saying that the vendor breakdown would be the more accurate summary to reflect our rebates.
Yes.
That would be.
Okay. What happened is, and just we're piecing together a story here for the judge. But what happened here is when you left the company, there was some stress that you had regarding getting your rebates, and that you were in fairly regular contact with Justin Jaime, demanding that he pay you his rebates. Is that a fair statement?
We had discussions. Yes.
And you were fairly aggressive about getting paid, and this is in the fall of 2016.
Yes, we had discussions about getting my money back. Yes.
The comment, though, the difference was you were fairly aggressive with Justin about getting paid.
I don't know that the discussion of fairly aggressive or the way that we normally talked would be any different, but you know, that we were in the construction industry, so vernaculars were pretty aggressive from go.
That's fair. I've represented railroad people.
Correct.
They put the construction industry to shame. So,
Yeah.
The fact is, let me, you know, I seem like I'm changing lanes here, but I'm not. Trust me. The 2015 rebates. One of the reasons they weren't paid in 2015 is that some of that money didn't come in until 2016. Is that true?
Historically, that happened every year. Yes.
And that's why the company still really would owe you 2015 rebates, because they didn't. By the time you quit, it wasn't figured out yet, and it came in. The money didn't even come in until 2016. Correct. I think.
Yeah.
And if it would have been identifiable, Linda Prater would have paid it. She testified that she paid the clear rebates that she knew about. So if Linda Prater had not paid it, it was not clear yet as of May of 2016. That's
right.
Will you agree with that?
I would agree with that. Yeah.
Okay. And so the point of that is the same would apply for 2016. That there's no way Justin is going to know in November, if you will, of 2016 what the rebate amount is going to be, because he hasn't even received all the information yet, has he?
Well, I think that there's a delineation between what rebates were being asked of and what rebates were not asked. Being the rebates that I asked Justin about were the ones that we had received in. We knew where they were and what they were, and versus as I stated, historically every year we had some coming in, and so it kind of ties up to our letter with you guys. Initially wanted us to just sign a waiver saying we were done, and you guys reserved the right to not give us any further funding, which kind of tipped the scales in the main direction. But we knew from the date that happened, we were still owed rebates that took the full year to calculate in 2017. So we were essentially waiving our rights to get any further money that we knew was going to come in 6, 7, 8 months, 9 months from the point you gave us the first.
And that's a settlement offer. I'm not just suggest that having a release of all claims is a common thing in a settlement offer, but it probably was premature. I'm going to give you that was a premature offer to make. However, there was substantial pressure for you to make an offer. Now, Justin was not the president or vice president or office manager prior to June of 16, was he?
So, excuse me, you said there was substantial pressure to make an offer.
Okay, we'll deal with that in a minute. But the question on the board was Justin was not the president, the vice chair, the chair, or the office manager the first 2 quarters of 16.
That's correct, but it doesn't, per Linda's
let me ask a question. You were the chair in the first 2 quarters of 16, correct?
I was the chair of the first 2 quarters of 16.
Mike Deneen was the vice chair.
Mike Deneen was the vice chair.
And Linda Prater was the office manager.
Correct.
And you guys didn't come up with a formula. You had options, but there wasn't a formula. Don't you think that when Justin steps into this mess It would have taken him a while to figure out what is going on and how to figure out these rebates properly.
I disagree with that comment. You keep referencing that we didn't have a formula, and you keep referencing that it was my call only and Mike Deneen's call only, when all of yesterday's testimony stated that every owner was involved in those decisions. It wasn't, I had no particular or individual right, authority, power to make an assumption or a call based on everyone else's money. I had a title, but that went, as Linda stated it, she had 13 bosses at all times because everybody was involved with their own money. So I was never, I never challenged the authority of the title by saying I can just carte blanche this for everybody because we were a group. So you continue to say that we had a formula, or we didn't have a formula. We had a formula. We had a formula from 1997 that we utilized to get vendor rebates back to the entities that earned them. So
I understand that's your point of the case, but that all changed in 2015 when you signed a new contract with Embassy.
It did not change.
You gave up your right. You gave up your direct contact with the vendors, and Embassy became the entity that negotiated rebates. And so you lost that information from the vendors, and Embassy didn't give it to you. That is why when you quit, or when you got terminated, I don't know which way it goes. When you informed the board that you were selling your interest to Ferguson, and you and Mike left, and then Linda got terminated, that you had not paid. There was money from Embassy in the account that you had not paid up because you didn't know how to do it because the board hadn't approved anything. And that's the testimony that was yesterday.
That's it.
So I want to show you. I want to show you an exhibit that would.
I'm going to object to counsel testifying, Your Honor. He didn't ask a question then. He just went on and testified.
Well, the judge knows my testimony, that I'm a lawyer as an adverse witness. And I think the judge knows the difference between.
And I still think there needs to be a question posed.
Well, I'm going to pose a question here.
Yeah, I assume there's a question coming. Obviously, counsel's statements and questions are not evidence.
Okay, hold on. I want to show you an email that you sent to Justin Jaime. Okay, it has my name on it because it was sent to me today, but this is a copy of an email that you sent on November 5th. Well, that's today. That you sent on November 8th, 2016,
Okay.
from Nathan to Justin. I'm going to give you a minute to look at that, and then I'm going to ask you if you remember sending this.
Sure. Are you sure that I do?
Okay, well,
I haven't seen it though.
can you see it now? Is it on the screen?
No.
Okay, well, let me, this is I forgive, this is my noviceness about dealing with these exhibits I'm learning. How about now? Is it on there now?
Yep.
Okay, thank you. Sorry, thank you for your patience with that. Tell me when you're done reading it.
Okay.
All right. Now, is this the tenor of the conversations? Is this what you called friendly between you and Justin?
I would say that at any particular point in time, any of our board meetings, we had discussions that were slightly heated, but this would be, one of those slightly heated moments.
Because at the very last sentence, I understand, he didn't expect to be running the president of the company. He didn't expect to be dealing with how to divvy up the rebates. He got thrown into this in basically July. And this is just a couple months later, before all the rebates were even in. And its last sentence, all of these owed funds need to coincide to the penny with the amount of money that I received back from Michigan Pipe Co., or I'm going to charge for theft.
Okay.
Threatening criminal action here.
Well, if I felt that something was stolen from me, I guess in my mind it would become criminal at that particular time or kept from me unwillingly. I had no control over any of the funds that that were owed to me throughout this entire process. I had, I was removed from any of that opportunity.
Okay, and so I understand your frustration that during this period there was a lot of unknowns. You advised them on short notice because of your promise, your confidentiality agreement, and they reacted because over half of their sales just left. That's a big stressor to the small company, and Justin's trying to figure out. He's not just dealing with figuring out rebates. He's dealing with the survival of Michigan Pipe Co. You're worried because you feel you're owed money and you're not getting it, and you want the money. And but it was pretty ugly. You were demanding that he give you money, and this is relevant because I believe, like you believe, that December offer was probably premature because Justin, all the embassy money was not even in. There's no possible way it could have been vendor based. It was just Justin doesn't want to be charged, even if he doesn't think he would. This is ugly. He wanted to resolve a dispute. So this is also evidence that there was a dispute that Michigan Pipe Co. was trying to resolve this acrimonious issue with you.
He had no objection to the fact that there was money being offered to us in a certain fashion. We had objections to the fact that it came with a take it or leave it letter at a time when we were asking for different requirements. It also came without any substantiation or willingness to let us substantiate those values. So when you talk about if I say, if I have $100,000 in a bank account and you're going to give me 50,000 back and not tell me why, then I have a right to know why you're not giving me my other $50,000. So you sent a letter with a claim that, again, we didn't argue the fact that what the value of the money is. We argued the fact that you gave us a take it or leave it letter, knowing full well we had rebates coming in 2017 to account for the first 2 quarters of 16, as well as we asked for the ability to review the records to coincide with that value for the duration that we belong to Michigan Pipe Company. So
Mr. Barwick, you're talking about December. This letter with you threatening to call the police or threatening to charge for theft, this happened in November. You had not gotten any letter from anyone yet. And then the letter that you got, hold on, the letter you got was in December. You never gave at any time prior to the lawsuit a counter demand. Because I would like to see it to this date. It wasn't until I didn't receive any counter demand or needed in Michigan Pipe Co. You never made a demand. You just said, give me, and
no,
you didn't know.
That's inaccurate. We never said, give me.
I'm going to interrupt. If there's a question in any of the many statements you've made, it's lost on the court.
Okay.
If you put a question mark at the end of it, it would be objectionable as argumentative. We've got an argument taking place between the cross-examiner and the witness. that's inappropriate. If you have questions you want to ask them.
Okay, thank you, Your Honor.
I'm
I
sorry.
would like to move that 41 under and as an exhibit. Admitted as an exhibit.
Judge, I object on the basis that this was never provided. I don't understand why, if counsel was going to use this exhibit, why it was never provided to us in discovery.
I didn't think I'd have to use it in response, Your Honor. It's done as and to impeach the witness because he is pretending that we are the mean ones. When I say we, that Justin Jaime and Michigan Pipeco, and the temperature in this, when these settlements were offered, it was a contentious relationship, and they were in fact offers of settlement, and that's why there's releases, because there's threats. And so it's, it's an impeachment evidence, Your Honor.
I'd leave it to the court's discretion, Your Honor.
Looking at the date of this, if this was within the scope of a discovery request and was not produced, I'm not going to allow it into evidence now.
Well, I would like an opportunity to see if it was produced, but Your Honor, this comes from Nathan.
That's not the point, counsel. I'm not ruling on its authenticity. I'm not ruling on its relevance. I'm ruling simply on the fact that if this is something that was, oh, wait a minute, back up a minute. Yeah, I'm sorry, I missed your point. I see it now. How could Mr. Volwinkle claim that something he sent wasn't produced in discovery? He obviously had to know about it. I'm going to allow it for what it's worth. Frankly, this back and forth about whether there was a fair offer or there wasn't a fair offer, I'm not going to be making a decision in this case based on whether or not I felt one or the other was being reasonable. My decision is going to be based on how much is owed, plain and simple.
Oh, so is the court already concluded that it's owed? I mean, have we passed the point that there's a contract? I mean, has the court ruled?
I didn't make any ruling. I said I'm going to be deciding this case based upon whether or not it's been established that money is owed. I'm not going to be making my decision based upon whether or not someone behaved unreasonably at any point in the process.
Thank you, Your Honor. I do apologize for the tenor of the recent exchange.
So this is 41. I'm going to need a copy that I can mark.
I believe we emailed one to you already, Your Honor.
Okay. 41 is admitted.
Thank you, Your Honor.
Thank you, Your Honor.
That email had.
I'm going to change directions a little bit, Mr. Volwinkle. You bought the company in 2015, correct?
That's correct.
And you took a course on how to sell a business during 15 or 16? Is that true?
I did. That's correct.
And when was that course taken?
I would have to look and see. I believe it was in the middle of 2015. I can't say with certainty, but I remember exactly where it was at.
Okay. And when, regarding the Ferguson negotiation, did they contact you or did you contact them?
Ferguson contacted us.
And when was that contact? Do you remember that?
Late 2014.
Okay.
They contacted Michigan Pipe and Valve Lansing.
Okay. When you bought into Michigan Pipe,
I'm sorry. I'm a late 2015. I'm sorry.
Okay. Okay. Well, that answers my next question. So thank you for that clarification. You have every right, and I want to make sure that I'm not questioning that. This is a business. We're all adults, and you can buy and sell an asset that you want. My question is, did you ever consider, once you start negotiating for the sale of your shares, knowing that you are by far the largest in sales shareholder of Michigan Pipe Co., did you ever consider resigning as an officer?
I did not, because at the time of, I had not agreed to any form of a sale. Therefore, I still had to have the fiduciary responsibilities that I took as that position for my own entity, just the same way that I had with everyone else's entity, because if June 27th, as I stated yesterday, if June 27th came and the final negotiated values were under what our predetermined values were going to be, there was no sale. So for me to just let the horse run as a result of being in negotiations would have been pretty negligent on my part, because I wasn't sure I was going to hit the button until after their final calculations came in for what the sale was going to be.
But resigning from the role of chairman wouldn't have really affected your ownership or your relationship with Mr.
Judge, I'm going to make an objection at this point as to relevance. I don't know what this has to do with the award of rebates.
Well, that's a fair question, Your Honor. Could I address that, or do you want me to shut up?
Well, he made an objection. If you don't address it, I'm going to rule in his favor.
Okay. This case is about a breach of contract. When I look at the complaint, the pleadings define the case, and it's a breach of contract. And the contract is, we're trying to figure out what the terms of the contract is. One of my defenses is that there are no terms to a contract. They said the contract occurred in January of 18. There's no evidence that there was ever a meeting of minds that we're now entering into a contract. And so that partially I worry that the only way that we're going to enter into a contract if this court steps in and says, I'm going to use equitable powers. And so some of this issue of fiduciary duty and breaching the fiduciary duty really are related to the fact that I might have to argue unclean hands. I don't think it's pled, to be perfectly honest. And if he's not going for equitable relief, then I'm going to withdraw and not ask any more questions like that. But if he's going to ask for equitable relief, then I have an obligation to try to educate this court and use unclean hands as a defense.
Sorry, was that a statement for me to act on, or were you talking?
No, I'm talking to the court right now, Mr. Blanco.
I'm sorry. Too many people were talking. I'm sorry, Your Honor. What'd you?
This is for me.
Oh, okay. I'm sorry.
And so, Mr. McCann, what Mr. Miller is saying is, if you are asking the court for some equitable remedy, that he has the ability to address the equitable defense of unclean hands, and that a breach of fiduciary duties might very well provide a equitable defense to whatever relief that you would be asking for. So I guess I need to ask you. I didn't look at the complaint or whatever complaint we're operating under. Clearly, there's no written express contract as to the payment of rebates. Based on the testimony I've heard so far, which is incomplete, there certainly appears to be an understanding by which the parties operated for a number of years, that when rebates were paid by vendors, that those rebates would be equitably distributed among the various entities based upon their contributions to the sales or purchases, if you will, that generated those rebates.
I would agree with that, Your Honor, and I want to reserve all.
That's your theory, that we
Correct.
have we have an agreement in place that's proven by the course of conduct of the parties. If you had a theory of unjust enrichment, but I don't think you're advancing that. I think you're advancing a theory of oral contract, which there certainly appears to me, as of now, to be sufficient evidence in the record from which if the proof stopped now, granted Mr. Miller hasn't had a chance to put his case on, but if the proof stopped right now, there's enough in the record from which I could conclude, yes, indeed, there was an oral agreement in place for the sharing of these rebates as they're provided by the vendors.
And that is what we have alleged in our complaint, Your Honor. That is our theory.
I don't think that's an equitable claim. Based upon that, we don't need to talk about, there's no claim in here for breach of fiduciary duties. There's no counterclaim. So on that basis, I believe the objection that this is irrelevant is sustained.
And as I indicated, I would agree. So thank you for the clarification. So now we just discussed the concept of a contract, and this lawsuit is a contract damages. And I believe you testified that in your mind, the contract was entered into in January, at the January meeting in Acme. Do you remember that testimony?
The contract of the lawsuit was entered into, or what contract are you talking about?
Well, you are suing Michigan Pipe Co. for breach of contract. And so I would like to know when that contract was entered into and what the terms of the contract are, if you have that.
Well, if by contract we're stating the context of how the organization was run, it was entered into in 1999 or 2000, as everybody has agreed to in their testimonies throughout yesterday and today. But so I would have, we as Michigan Pipe and Valve Lansing would have entered into that contract in the late 90s, 2000.
So the testimony that this contract was entered into in January of 2015 is inaccurate.
Well, there's a second component to it, but right, so there's an embassy contract that Michigan Pipe Company was entered into, as well as the contract or the standard operating procedures that we had prior to that.
So in 2015, there was a substantial change in the rebate method in that you stopped doing it yourself as an entity and had the entity contract with Embassy Group. And is that correct?
There was a change, not substantially to the rebate. There was a change in how the rebates were received. So they were received as a single party check versus a multiple party check. Correct.
And before Embassy, it would be Michigan Pipe Co. that would negotiate rebates with each of the vendors. Correct?
That's incorrect.
Okay, what is correct? Who would negotiate rebates with vendors prior to Embassy Group?
Well, individual entities would, we would talk about that. We had a board meeting that we would, as a group, we would agree to their proposals for rebates, but a vast majority of the rebate discussions were had over a dinner, we all had opportunities because we all had strong points with certain vendors that gave individual bargaining power versus the collective bargaining power. So Michigan Pipe and Valve Flint was a ductile house, and they sold a lot of ductile iron. So they could typically influence that rebate structure. Michigan Pipe and Valve Saginaw had a substantial relationship with PVC manufacturers that we didn't. So most oftentimes they would have discussions, meetings with them, and then at the subsequent board meeting, they would bring their proposals to us as a board, and we would then learn of maybe what the new rebates were, and we would agree to them or disagree with them.
After Embassy was entered into, it was Embassy that negotiated the rebates with the vendors, correct?
Not entirely. So
How is it incorrect?
incorrect. I'll answer it incorrect.
How is it incorrect?
Because before we entered into Embassy's group, buying group, we had substantial conversations with the individual vendors that we were accustomed to dealing with on an individual basis to ensure that we weren't going to go backwards by way of negotiations or overall rebate. So take Star Pipe, for instance. Star Pipe Products, they were a fitting manufacturer. We had arguably one of the best rebate structures slash cash discount offers that they provided in the country, even through Embassy, to the point where they would keep some of their rebate information hidden from the corporate office because it was so substantial. So we had a conversation prior to the Embassy group, or subsequently with the Embassy group discussion, saying, if this rebate is going to go less than what it was before, we had a deal with them saying that they would prop it up on the backside to make sure that we didn't go backwards. So Embassy, that was just one scenario. Embassy wasn't wholly responsible for our rebates, and then we were just hands off. We wanted to make sure as an organization, our efforts from the past, i.e. Tommy Ryan, Gary Putro, Jaime Sr., or Justin and myself and Mike Deneen's efforts, the Traverse City's efforts, didn't get disposed of because we agreed with Embassy. So we wanted to make sure that those rebate structures were going to, at a minimum, stay the same and go up. So they didn't provide all the negotiating power for us. Is why it's inaccurate.
Is it your testimony under oath that after you entered the contract with Embassy Group, Michigan Pipe and Valve would still negotiate for vendor rebates for those vendors that were part of Embassy?
That question does not reflect the statement I just made.
I know it's a new question.
Okay, under oath, I cannot answer that question because it's a deviation from what I just explained to you, and it's incorrect in the statement of the question.
It's a yes or no, and I'm sorry, but you like to take my questions and then re-answer them, which is for the good witness. So the question was, I'll repeat it one more time. After the contract with Embassy was signed, for those vendors who were part of Embassy, is it your testimony under oath today that Michigan Pipe Co. negotiated the rebate terms with those vendors?
That's an incorrect statement.
So you disagree with that?
I have to disagree. It's not correct.
So you're saying that Michigan Pipe and Go did not negotiate the terms with the vendors that were part of Embassy?
And that's not what I'm saying. What I said to you was we had the opportunity to continue to work with those vendors individually to ensure our organization wasn't going to go backwards by way of effort so it was an open opportunity for us to ensure our values were going to remain the same or get higher, as Embassy claimed.
After the contract with Embassy, who negotiated the rebate terms with the vendors that were part of Embassy?
In concurrence with what I just stated, Embassy had their platform that they provided to us. And should we determine it to not, we still had open dialogue with individual vendors to promote or encourage a side deal both of them, in essence, had some negotiating power.
So is it your testimony that the contract that Michigan Pipeco had with Embassy allowed you to continue to negotiate with vendors that were part of Embassy Group?
I'm not speaking entirely in the context of the contract. I'm going based on conversations we had with vendors in conjunction with Embassy. So,
I know, but I'm asking a question about the contract.
if you're asking me a specific, I don't have the contract memorized to be able to put myself under oath and state exactly what you're asking me against the contract.
Then you can say, I don't know. I just asked you a question. If you don't know it, I should have made that clear, and I apologize. If you don't know an answer, I don't know is an appropriate response.
I did not know that, so I apologize. I will store that.
Okay, thank you. You testified, I believe, under oath that Michigan Pipeco did not provide you a summary, that you had to get it from of the rebates that were due, that you had to get it from Christina Heath. You remember that testimony?
Not specifically.
Okay. Do you admit today that you got plenty of information from Michigan Pipeco in the discovery process about rebates and about how we came up with the rebates?
No, I would disagree with that statement.
Well, I want to show you a document that I'm comfortable. Well, let me show it to you. And I have to ask again, do you see the redacted statement? Is that on the screen?
Yes, I can see it. Yes.
Okay. Now, this is one that Justin Jaime prepared in 2018. Do you remember seeing this document?
Yes, I do.
Okay. And this document is one that was done, probably the last summary done after all of the information was in. And I would like to know why you chose not to use this summary, but you chose to use a summary that was provided from December of 2016, well before Mr. Jaime could have had all the facts for a basis.
I'm not sure which other summary you're referring to.
Well, you provided testimony yesterday regarding the summary that was attached to a Christina Heath letter to Tom Basil. I think it was. Let me just see.
Is there an exhibit specific?
Yeah, I believe it was 20. Let me. Yeah, that was in February, but I believe I'll get it up. It was 20. Let me stop this. And let me pull up 20. Okay, now is the bond letter dated to February 16 to Tom Basil up? Is it?
It is not up. No.
Okay, then I'm gonna. I'm getting the hang of this, but it takes an old dog a little bit. Okay, now is it up? Can you see the letter now?
Yes.
Yeah, is my audio not good?
I heard you. Yes, I can see the letter.
Okay.
Yep.
Okay, this is the letter. You gave some substantial testimony from this letter yesterday, and there's some documents that was sent to Tom that were summarizing how they came up with it, and I believe you used this. This was from page 5 or 6. This says 5, but I think it's page 6. So you chose to use this as your base to then you did your own modifications to come up with the dollar amount, and I'm curious as to whether or not it was a conscious decision to, where was that one?
I I think it's important to note the date at which that letter was written versus the date at which we received it. So additionally, it's important to note the date we received the redacted emails versus the date we requested them. So, you know, these values that you're speaking of, the first time that we saw those accurate calculations on the Tina Heap exhibit were well after that letter was written. In fact, that whole exhibit was excluded from any of the subpoenaed information that we had requested from Justin or Michigan Pipe Company well before this. And the only reason that we would find that document is because it came in through the subpoenaed information from Tina Heap. So we took that, since it was received by us, I believe, the beginning of 2018, as a statement of information that was provided for the case. So that was the basis of us using it.
But no matter when you received it, it's clearly a document that was created on or before February of 2017, correct?
No, the letter was dated that. I don't know that particular sheet has the same timestamp as the actual date on the letter.
Well, you know, then your attorney attaches as one exhibit. Are you suggesting that he attached documents to that letter that really weren't part of the letter to get them into evidence? You know what I'm saying? Because when I see that this is part of the heat depot and your attorney attaches as an exhibit, I'm taking it at face value that all the things that are attached to this were part of that letter. Is it your testimony that you don't believe these exhibits were part of that letter, that they were somehow unrelated to the letter?
No, what I'm stating is that we received that information from Tina Heap. So when we compiled that as one of the emails that she has, or one of the documents that she had provided us, you know, in its whole entirety, that page was in there.
Let me just ask a different question. Do you know, as you're sitting here today, when page 6, even though it says page 5, when page 6 of Exhibit 20 was created?
I know that it would have to be later than 2016, and you know, so within 2017.
So it would be somewhere between January 1st, 2016 and 2017. Was that your testimony?
Inaccurate. I said it would be later than 2016, and with these totals and with the additional information. If you scroll down, if you go ahead and scroll down, we knew we had additional money that was added that came in later in 2017. So our assumption was it was after the annual rebates were distributed or calculated from 2016, but received in 2017.
That's an assumption you made. And the question is, do you know when this document was created?
I cannot say exactly when that page was created.
So is the answer no?
No.
No, okay.
No.
No what?
No to your question.
Okay, thank you. Now, in the other exhibit, the one that you say you didn't get for a while, but I'm going to represent that you know, your counsel had a little bit of difficulty asking the questions, and the court actually propounded questions. But this was submitted to your counsel over a year and a half ago, and this was done in 2018. We actually had a court hearing on this particular exhibit. And so since this is the latest summary done by Justin Heine with all the information that he had,
Mm-hmm.
and all the emails, and it was based on, if the testimony is that this document is based on vendor calculations, vendor information about how you distribute the money,
Mm-hmm.
with you having a problem with using this? Do you have a problem with this exhibit?
Scroll down. I want to make sure that.
Well, okay,
Scroll down. Okay. So.
You want me to enlarge it so you can see it better? Because it's really not substantially different. It has rebates totaling $269,632.26.
Correct.
Did you make a conscious decision not to use this, or did you just, I just wonder why this wasn't. I assumed that this was going to be used by you guys because it was the last summary based on vendor calculations, consistent with what Linda Prater. It took forever to come up with these numbers. And so I just wondering, did you discuss or did you consciously decide not to use this, or you just didn't appreciate that? And I'm going to have to authenticate this further with Justin Jaime, but this was based on vendor calculations.
Yeah, we used that calculation. We had used that calculation, as we were accumulating all of our different numbers, and essentially that calculation, as well as the calculation stated in the email from Tina Heap, we came up with a difference of about $11, and I think Michael's was $11 and change. I ended up at $271,701.76, and Mike was $187,88,066, and we felt at that point in time that the calculations that we had used based on the information that we had prior and accumulated over time, that they kind of checked out.
But if the evidence shows that the earlier settlement proposals, or take it or leave it proposals, as you would call them, were not based on vendor calculations, and this one was, would that cause you, even if it's only $11, would that cause you to say this is the one that should be used because it's the most accurate?
I don't think that any of the 867 pages of information that we received would be individually isolated. I think that's a culmination of all of the different pages and trying to, again, this is based on items that we've asked for, but when we put these numbers together, of course, we want to check and balance to make sure that our facts and figures are relatively close to what we thought they would be. So, whether it's relevant, if that's the latest and most accurate, it's not. It could not be. But again,
why could it not? Why do you say it could not be?
I misspoke. I'm sorry. The fact that if we have this document, in addition to other particular documents, and we come up with a calculation that is literally within $1,000 of what our claim is, and that's taking into account, again, we have management fee discrepancies that we're calculating. We have bogey and silent rebates that we're calculating, and we're trying to make sure that those are all included. And so if we take the entire encompassing calculation of all 800 sheets that we felt were pertinent information, this document versus the document we used literally came up with $1,000 difference on mine and an $11 difference on Michael's. So I think that it's safe to say that both documents were relevant to the case.
So I will submit that this does not even pretend to deal with management fees. This is simply prior to any set-offs, rebate allocation. So any arguments that we have about management fee, we'll make. You and I have already talked about management. All right. So I would like, this one has not been entered in, and the reason, this is part of discovery, and it's the most accurate, and I would like this entered into as exhibit. I'm going to move to have this entered into as exhibit 42.
So,
well, let me ask first,
okay.
Mr. McCann, do you have an objection to that, first of all?
I don't have any objection to this exhibit being admitted.
42 is admitted. You had indicated earlier that I have 41 I don't think I do. I looked to see if it had been emailed. This one I do remember getting an email on. I think I printed it, but I don't have my court officer to go fetch it for me. I'll verify that. And if I have it, we'll just mark it. I need to take a break
And I
to
will
handle
email
a
it during the
couple.
break, Your Honor.
Okay, I'll be staying on the record. I have to handle a couple front of the court enforcement matters. I'm going to leave you guys in the courtroom, but I'll be dealing with another matter.
Okay. I'm gonna leave in order to get this email, that I'll be back. Okay. Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Are you saying I can get up?
Yeah, you're free. I'm handling a different matter now.
Okay, thank you.
Oh, shoot. Mr. Miller left his screen share up. Can you take that down? It interferes with my Zoom. Thank you. All right. Good afternoon, Chad. We're in the middle of a trial on another matter, so sorry to keep you waiting.
That's fine.
And I see someone logged in with a telephone. What is your name, please?
Damian Gwynn.
Damian Gwynn. Okay, hold on a minute.
Yes, sir.
All right, let me find these files. So it looks like I've got two files involving Mr. Gwynn, Pulley versus Gwynn, and Rabbit versus Gwynn. And if you sent me a summary on these, Chad, I don't know what I did with it. Could you bring me up to speed on both files?
Absolutely, Your Honor. Mr. Gwynn's 2002 file is showing a balance only arrears total of $16,370.77. The last payment we received was on December 13th, 2019. That was in the amount of $25. Mr. Gwynn's 2002 file ending in 608DS, the balance only arrears total of $6,372. Last payment we received was on December 13th, 2019 in the amount of $25. We're here because the defendant appeared before referee Murphy on October 16th, 2020. No agreement could be reached on how to pay their arrears on either file.
Okay, Mr. Gwynn, are you currently employed?
No, sir. Under the table. I just started a job under the table.
So you don't have a W-2 employer, but you've got some kind of source of income currently, correct?
Yeah, I just started working with these guys. They're doing leaf removal. Cause pretty much all my life I've just been working like under the table construction, landscaping, roofing. I had a few jobs like filling out applications, but not very many.
Now that you are at least receiving some income, how much?
Yeah, I just started.
How much per week would you be able to pay for for these two files? Do you live in Jackson?
Yes, sir. Yes,
How
sir.
much you think you could come up with?
I can pay like $50 a week. Because the guys I'm working for now with the leaf removal, they pay me $10 an hour. So right now it's like a busy season with leaves, so that's currently what we're doing. And then after that, they got like snow removal, so I'm gonna be helping them do that. So, and they just pay me like $10 under the table.
So Chad, has Mr. Gwynn been on the pay or stay plan in the past?
He does have one prior contempt, but that was for a payment plan failure. There has been no pay or stay.
All right, and are they doing pay or stay currently? I mean, are we still COVID problems?
We're still, they're not lodging due to COVID.
So the best I can do is a payment plan. What would you recommend, Chad?
For the 2002 file ending in 3000 DP, which is the $16,000 arrearage one, I would recommend $50 biweekly for 30 weeks, starting on November 13th, running through 6/11 of 2021. For the
Okay.
2002 file ending in 608 yes, I'd recommend $25 biweekly for 30 weeks, running for the same dates.
All right, and tell me again the number you're recommending bi-weekly. I missed that.
For the 2002 file ending in 3000 DP, $50 biweekly. And then the 2002 file ending in 608 DS, $25 biweekly.
So that's $75.
That's $75 every 2 weeks.
Okay.
So that's well within what you told me you thought you could pay. That sounds like a reasonable recommendation to me.
Yes. Yes.
Since Mr. Gwynn has already indicated that he could pay that, that's what I'm going to order. Those payments will begin, I'm sorry, what was your start date?
November 13th, that's next week.
Okay.
Running
All right, so your first payment will be due next week, a total of $75, 50 for the larger file, 25 for the other, and then
So that's 50.
your next payment will be due 2 weeks after that.
Yes, sir. So that's 50 for Kanea Rabbit and 25 for Shalonda Pulley?
I didn't understand you. All right, apparently Chad did, so I'll take that.
That's correct.
Okay, very good. Chad, you'll write these up, please?
Yes, Your Honor.
All right, I'll watch for those. Mr. Gwynn, make sure you keep up with this payment plan.
I will, sir.
The only real choice I have at this point, if you don't pay, is to throw you in jail. I really don't want to do that, because if you're in jail, you're not making any money, you're costing the taxpayers money. It's not doing anybody any good, but I cannot afford to let you just ignore these obligations. So please stay with it, make these payments.
All right, I appreciate
All
it.
right.
Thank you, sir.
Have a good day, sir.
Thank
Let's see,
you.
we've got one more file. The matter of Brickner versus Yeager. This matter was scheduled for 3 o'clock. Mr. Yeager has not appeared. Would you like the court to issue a bench warrant?
Yes, Your Honor. Bond will be $775.
I will sign that. I'll watch for it.
All right, great.
Thank you, Chad.
Thank you.
You're welcome. Have a good day.
You too.
Shannon, just take us off briefly. I'm going to take a short break here.
Remember, I don't see Kevin tonight, so when I scoot out,
That's okay.
okay. I know, but this happened to be a lot of appointments this week, so I don't want you
Well, but
yelling.
every one of them has been extreme.
But I don't want you yelling at me and thinking I'm a slacker.
It's safe.
How long is the break?
State Police, it's right behind Trinity. It used to be, I don't know if it's still is.
Okay, Shannon, put us back on.
Hang on.
All right, we are back on in the Bullwinkle matter. So, Mr. Miller, I did find the most recently admitted exhibit, which I believe was 42. But I can't find 41.
Well, I just talked to my legal assistant and said, we need to send this. And then, okay, I'm sorry to share this with everyone, but she said, you never told me. So, so she's sending it now. So,
Okay,
the one that's missing.
I will watch for it.
In light of the issue regarding unclean hands, I'm about done. I just have one area to go into, and then I'm done with Mr.
Very good. You may
Judge,
continue.
Judge, I'm sorry. Could I just take another minute? I'm about to lose my AV man, and I wanted to see if I could prevent that if possible.
Go ahead.
Thank you.
Hey, Judge, just so I have this on our calendar, are we going back tomorrow morning?
I think so. Tomorrow morning,
What time?
8:30, I
You got a
think.
prediction for Saturday at Iowa?
Oh, you know, I have to consult with my oldest, the 14-year-old, to get the statistical data for the Spartan football team. I get more hype on the basketball stuff.
Yeah, that's true. Well, understandably.
Yeah.
My son is easy. You just say Michigan State, no matter what.
Yeah, valid. I don't know. The jury's still out, just after their first two performances. I don't know which team will show up.
Yeah, which kind of makes it fun.
Yeah.
Are we all set, Mr. McCann?
Yes, I am, Your Honor. Thank you very much.
Go ahead, Mr. Miller.
Mr. Volking, I just want to go over some testimony regarding the empathy and decision-making. And really the point of this is to just establish the difficulty that Justin Jaime was having with the credibility of the various summaries that he was doing. And this is page 28, am I at 28? Yes. So first of all, do you have the deposition up, Mr. Bowinkle?
I can see it, yeah.
So this
Yes.
is page 28, and we're having a line of questioning, and I want to just move off that and let's move to embassy. And my question was, when you make a purchase under embassy, is that, and this is my great questioning, was it that simple that you could just apply a percentage to your purchase? Now, in context, we can, if you want to go above and read it, but we're talking about your testimony that when it accrues, when you feel, and I'm not even questioning that here, that when you make a purchase and it's paid for, that you felt that you had a right to a rebate. And under the old law, you had a very good idea what that rebate would be. And so then I'm moving to embassy, and I said, when you make a purchase, is it that simple that you can apply a percentage to your purchase? And your testimony, could you read your testimony on page 15?
Okay. Where would you like me to start?
Just read on 15.
Oh, 15. I thought, okay, I'm sorry.
On 15.
It wasn't that simple.
And I said, did you know the formula that embassy used?
No, embassy didn't use a formula.
Well, how did embassy come up with the amount that they decided to pay Michigan Pipe Co?
No, embassy was a negotiator for everything that had to do with the rebate.
Right.
Embassy was the one that determined how much, so they had a percentage or an agreement with the vendor that then transferred through to us.
Okay, and so at least in your deposition testimony, it was your testimony that embassy was the negotiator for everything that had to do with rebates, and that's relevant in that when you left, and Justin, I'm not gonna. That's my argument. I'm not gonna make. I don't have a question pending. So thank you, Mr. Bowinkle. That's all the questions I have.
Okay.
Redirect, Mr. McCann.
Yes, Your Honor, thank you. Okay, Mr. Volwinkle. A moment. Yeah, Your Honor, I did lose my AV man, unfortunately, so maybe I can borrow from Mr. Miller, might be able to help me out a little bit with pulling up an exhibit or two.
I will, Mr. Wade, or Mr. McCann, if you tell me what exhibit you want, then I will pull it up.
Thank you, I appreciate that. Okay, so if we could go back to page 57 of the transcript for a moment,
You want me to pull it up?
please. Page 56 going into 57.
Okay. Up in the top left corner.
Yeah, I'm 46.
Okay, there you go. So we need 56, you said, Wade?
Yeah, the bottom of 56 going into 57. Okay, and this is where Mr. Miller had been questioning you about whether you felt that the management fees were accurate for the $100,000 or $90,000, and you had said, I never claimed that I don't own those management fees. And on the top of page 57, I don't think you got a chance to get into your answer lines 4 through 7. And at that point, you said I would, I'm sorry, the management fees, I never said that I didn't owe them. I would contesting how much they were as related to the amount of service that was provided to me through Michigan Pipe Company and through the understanding we had with Pipe Company. So it's you actually were not contesting that you owed the fees, right?
That's correct.
Okay. But it was just in relation to that amount that they're projecting that you owe, correct?
That's correct.
Okay. When
Are you done? Should I stop?
yes, I'm done with that one. Thank you. With regard to the sliding scale that's used to compute management expenses, did you want to expand on how you felt about the way that affected the amounts people were due at the amounts that were due from each of the MPVs?
Yeah, the sliding scale, as I mentioned earlier as well, was simply used to mitigate the excess cash that was going into Pipeco that could have been more effectively used at the individual entities to pay down their bills quicker, to take cash discounts, and so we tried to come up with something that was fair for everybody because we realized again that the cost to process my sales as it related to the dollar amount would be they didn't have a linear relationship. So our sales were growing so quickly, and everyone's sales were growing so quickly, and but the need for us to double our staff at Pipeco versus our sales doubling didn't happen. So, we had stated earlier or stated yesterday, we were in the commodities business, and I could see a 25% increase in commodities year over year, but I would be processing the same amount of paperwork. And so if the sales totals were going up due to, substantiated increases in cost of materials, then the actual workload to get through that sales would be the exact same as the year before. So we just felt as an organization, we were giving so much money to Pipeco that we then waited until poor Linda, December 31st, would sit and try to figure out exactly how much we would get back so that everyone got it back out of Pipeco before their year end. And so
Was
Sorry?
it your experience that people got back their excess in management fees?
Yeah, we did. Yeah, we received money back, and it was based on a calculation that Linda had as she was closing the books for Michigan Pipe Co. for the year. Tina Heap would interject on, losses, depreciations, things like that to effectively get the taxes ready for Pipe Co. So we would get monies back.
And would that typically be anything beyond the $50,000 that they kept in the Pipeco account? Would anything else be given back to the particular MPV?
Yeah, that $50,000 became a benchmark for us to not go below. Prior to that, most of it would be given back. We determined that it was moving a lot of money back and forth, and we could take advantage of some tax breaks through Pipeco tax advantages to leave that money in there. And essentially, what we started doing was we started accumulating retained earnings in Pipeco. So there was a significant amount of retained earnings in Pipeco just in a few short years of that process of leaving some money in.
All right, I'll get to that in a minute. As far as management fees go, how often were they paid?
So that was another thing. The other thing we realized again, these conversations that I had, we were trying to streamline the effectiveness and efficiencies of our local businesses, right? And so we realized before Nate, we were paying our management fees on a monthly basis, right? So I'd have $1 million in sales, and I'd owe $10,000 the first week of the following month, and then I have $1 million in sales. So what happened was, as we tried to streamline the cash flow for each of our businesses, we said, if we pay quarterly, then that'll allow us to hang on to our money, allow our money to come back in through our receivables. And so we weren't effectively financing our management fees off of our line of credit. So what I came up with was we pay these on a quarterly basis. We can then group them together. We had average receivables of 90 days or so. And so if 120 days they were due, we would then have the money back in from those sales before I had to make a payment to Pipeco to pay for their services. So it became kind of a cash flow thing for everybody to help streamline the businesses.
So Michigan Pipe and Valve Flint and Michigan Pipe and Valve Lansing both paid their first quarterly management fees for 2016. Is that correct?
That's correct.
And then Flint was the only Michigan Pipe and Valve company that paid their second quarterly management fees. Is that correct?
Not entirely. They were the only location that paid their management fees earlier than the due date of the first week of July, which would be start of third quarter. So, which is why that we noticed in that the operating expense income statement from yesterday. That's why we had to make that adjustment, because they paid them earlier than the other locations. So, yeah.
So you hadn't paid your second quarter dues yet. And in the second quarter, you made approximately how much money?
Made or sold?
I'm sorry, sold. How much did you
we
sell?
sold just over 8 million, I think, in the second quarter.
Okay. And because of that, your management fees that they invoiced you for were substantially higher than what other ones were, right?
Yeah. So if you looked at the management fee totals that everybody was bringing in for that particular quarter, they were substantially higher. And to my argument, for the second quarter, we didn't bring on 6 or 7 more employees to facilitate those sales. We were able to process, get out, the operating expenses through June 30th of 2016 would reflect any overtime that we had to pay for those ladies to process the sales. So their workload was encompassed in that total, and we still did it without hiring any additional employees.
Right. And so there would that amount of money would not be you would be expecting to get a lot of those management fees back at the end of the year.
Oh, yeah. On pace for the same the same sales pace that I was on that particular year, I probably would have gotten a couple $100,000 back from or more from Pipeco, just based on how much was going in versus
What was needed to operate the business. Okay.
Yeah. Pipeco had a budget of.
Going back to your.
Mr. McCann,
Yeah.
let me jump in here.
Sure.
Mr. Volwinkle, can you tell me the method that was used at the end of the year to decide how much of the management fee to rebate to each of the individual pipe companies?
It's based on the percentage that we paid in or percentage of sales that we had, because our percentage paid in would be based on a percentage of our sales.
Thank you.
So for further clarification, if I was 40% of the sales at the end of the year and there was a $100,000 rebate, I would get 40,000 back as a means of what I paid in.
Thank you.
You're welcome.
And you were no longer working with Michigan Pipe Company after June of 2016, correct?
That's correct. Okay.
So would they need your payment for management fees after June of 2016? Going
No.
in from July through December of 2016, would you expect to be billed for management fees for that period?
No, I would not.
Why not?
Well, Michigan Pipe Company was set up as a means of services, administrative services, and our management fees were created to pay for those services. So in my logical progression, if I'm paying for services rendered and services are no longer rendered, I wouldn't have any expectation to have payment. But I guess.
All right, if we could pull up Exhibit 16, please.
Hidden there. Wait.
Page 4.
I think you have to get up and read it back in. Can you see that, Mr. McCann?
Yes, I can. Thank you. Can you identify that for the record, please?
That's
Mr. Volk.
Michigan Pipe Company 2016 tax returns.
Okay. And can we scroll to page 5, please?
Page 5. Yeah,
This
the
one?
bottom.
Yeah, it's actually this page here. Yeah, toward the right. That's good. That's good right there.
A little more.
Enlarge it?
You don't have to enlarge it. You can just scroll down a touch more.
Okay. And so referring, I believe it's in line 25 and also down there on the bottom. Can you tell me what that 167,710 represents?
The retained earnings for Michigan Pipe Company as of the 2016 tax year.
Okay. And those retained earnings represent what?
That would be the accumulation of our monies left in over time after we paid the taxes on them.
Oh, when would the contributions have been made to get to that balance?
Well, that would have been a portion of the money that was left in, the $50,000 that we all contributed to, annually. That would be the earnings as a result of leaving money into Michigan Pipe Company. It would show retained earnings.
So would you expect to be given any of that money back at the time you leave Michigan Pipe Company?
Expected, yes. Requested, no.
You didn't make the request for that.
Correct.
But what percentage would you think you would be entitled to based on your contributions to that?
not based on my contributions, just based on the fact that Michigan Pipe and Valve Lansing was a 20% owner of the entity. It would be, a 20% stake in the retained earnings.
Thank you. You can bring down the exhibit now, Mr. Miller. Okay, moving on. You indicated that Mr. Miller kind of went over with you the fact that an offer was made in April. I'm trying to remember which number exhibit that was. That
it was
20?
added this morning. Oh,
is that the one? No.
Yeah, the April one was this morning.
Okay. Oh, that's the new exhibit 40,
42, maybe 41.
42. At any rate, he was asking you why you didn't make a counter offer, and I think you indicated that it had something to do with the discovery. Can you explain that to me, please?
We still didn't have substantial information or adequate information to make a counter offer that we felt comfortable with. The discovery, and everybody on the screen will remember, the discovery took us a couple of attempts and a couple of discussions and further discussions from the judge to make sure that we had substantial information to prove our dollars out. So again, without being able to substantiate, the dollar amount could have been exactly what was owed, but without having substantial information or information to substantiate, it was going to be difficult for us to even make an offer. Now, I had, based on historical idea of how the yards went, I had an idea of what the rebate calculations should be, but without having any sort of accounting or discovery to substantiate my claims, it was seemingly worthless at the time to just throw a number back. And so we had gone back and forth several times on trying to get information as it pertained to it.
Okay, and we didn't receive the discovery that was used in your calculations until that was provided by Bond and Company in early or April of 2019, correct?
That was the information that we used to substantiate our claims.
Mr. Miller, could we bring up 810, please? Bait stamp 810, I believe that's 42. You.
See that, counsel?
Yes, I can. If you can scroll down a little bit.
Further?
Okay. Yes, and Mr. Volwinkle, that 269, 630, 226, what does that purport to represent in your opinion?
As the document stated, that would suggest the amount of money that was owed to me through rebate discovery and rebate accumulation.
And does that number appear to reflect the bogey rebates and silent rebates?
It does not, and that's based on a lot of the items being redacted. But if this were a spreadsheet calculating total rebates, there's no place in the left column that would suggest any sort of bogey or silent rebates. And again, as we calculated them out, looking at that number versus some of the other numbers we utilized, taking no payments, it came within pretty close justification.
And this document here was not really sufficient for you to come up with the full computation adding in the bogey and silent rebates and subtracting the amount of management fees that were due based on the percentage of sales that you had for the period of time, correct?
That's correct.
And is that why you used the other information that was provided by Ms. Heap and Bond and Company in order to calculate the amount of money that's owed to you?
Yes, that's why we used and that's also why we used several of those other exhibits in our explanation to try to substantiate, our pathway to a final number.
Okay. And can we pull up Exhibit 39, please?
Keep going. Scroll down. Scroll down.
Yeah, move this up. There we go. Is that visible, council?
I haven't seen it yet.
Okay, well, I'll go out and go back in then. Is it visible, council?
It is. Thank you. And Mr. Volwinkle, these are the computations that you did by using the information provided by Bond and Company, correct?
That's right, and other discovery, but yes, Bond and Company as well as some of the other discovery that we were able to piece together.
And Bond and Company was at 269,000 for you. Is that correct?
They were
and change.
No, sorry, no.
I'm sorry. The other information from Exhibit 42 showed you at the 269. That was computed later after this, right? I'm sorry. It was computed.
This.
Yeah, I'm sorry. It was computed after the letter from April of 2017 that also had information in it, including Exhibit number 42 with big stamp 810.
Yes, that is correct.
All right. And your number there is within $1,000 of the number they came up with, correct?
Yeah, well, 269 and change, and
yeah, so
271 and change, so a couple thousand.
Very close. However, their number did not appear to include, by what you just testified to, it didn't appear to include bogey rebates, correct?
It did not, but no, it did not.
And we don't know if management fees were removed either, so that might explain it, why it's so close, because I see on your chart, management fees that you calculate would be about 20,000 and bogey rebates about 19.
Yeah. So the calculation brought us it brought us a lot closer together than any of the numbers that we had seen up until that point.
And was that similar for the Flint calculations as far as the other numbers from the April letter of Exhibit 42?
Mike was within $11 according to that calculation.
Okay, thank that. I don't need that exhibit anymore. Thank you.
Let me clarify, because I'm having trouble with the $11. I'm looking at the column for Flint on Exhibit 42.
Yeah, so I'm sorry, the $11. Go ahead.
Shows 150,000, but Exhibit 39 shows Flint 186,000.
Yeah, so I'm sorry, it was a delay.
Go ahead.
I didn't mean to interrupt you. I was, so if we took the actual rebate calculation and then to get to Flint's calculation, we also had to do the management fee refund of 25,875 and then his silent and bogey rebate. And so if you put those two items back into the 155.48, it came out to 187,088. So it was really,
I
it
got
came
you.
out. Yeah. So the exhibit you see right now is excluding, in our assumption, excluding the discrepancy in the management fees as well as the bogey and silent rebates.
All right, I understand your testimony now.
Okay.
With regard to the letter that you received from Michigan Pipe Company originally back in, I believe it was December of 2016, late December of 2016.
Mm-hmm. Yes.
That letter, you characterize it as a take it or leave it letter. And I would like to know, did you, they characterize it that you were actually the bad guy because of the email that you had sent them and so forth. But in this letter, was it also made known to you that they didn't feel that you deserved any money or any part of your rebates, and that you could take this and sign away all your interest in the name Michigan Pipe and Valve Lansing and take this check for, how much was it approximately?
103,000 and change.
Yeah, you could take that check, or you could we don't believe you deserve anything, but you can take this and pay these fees. And they're, as Mr. Miller had described it, a bunch of willy-nilly fees that don't add up to very much. They don't seem very logical when they start adding all the different fees they tried to remove in order to get you down to that figure. Would you agree with that?
I would. And I think that most notably on the letter was, I believe up until that time it had been discussions back and forth with the old organization without attorney interest. And, that came to us. That to me was the tipping point of amicably resolving this issue wasn't going to happen anymore. And, although there were plenty of conversations throughout the years with other board members that got, they were elevated conversations in the boardroom. We were a bunch of alpha humans that were trying to operate our businesses the best way we knew how. So we were loud at times, but at the end of the day, we were still amicable partners in the game. So when I got the letter, that was pretty much the decision that it was not going to be amicable anymore. And so when there were items in there that would prevent me from potentially going after money I knew was still out there, that's when it the tides kind of changed on how how it was going.
And some of the fees that they tried to attribute to you were for legal fees, for accounting fees, and the statement of Tina Heap of Bonding Company was that she did not experience any increase in volume of work whatsoever after the breakup of Michigan Pipe and Michigan Pipe Company after yours and Mr. Deneen's departure. Correct?
That's correct. Yeah. I felt that, again, it was a statement made to get, or a document made to get a number where they felt comfortable, giving it to me and hoping that I signed it. But, upon further review, there were some charges that we hadn't typically been accustomed to paying or needed further explanation. But, again, all of it wasn't substantiated with documentation. We weren't allowed to check and balance the number that was given to us. So it was essentially, in my mind, just a kind of throwing a dart in the wind and hoping that worked. But we had agreed that if it was the number based on our findings, we would take our check, we would move on. And that was vocalized from the beginning.
Did you feel a little bullied when Michigan Pipe Company's lawyer told you that you are not entitled to get anything and it's against my advice that the members of Michigan Pipe Company are even willing to make you any offer? Did you feel bullied by that?
Your Honor, I have to object that.
This line of questioning is not helpful. Whether somebody was bullied or somebody was unreasonable, it's just not helpful to me. I think you should move on to something else.
Okay. I apologize, Your Honor.
Oh, we're back.
So in explaining your rights with Embassy to get rebates, Mr. Volwinkle, you indicated that you still, even after Embassy, I mean, your transcript suggests that Embassy did the negotiations. Is there a way for you to explain what you meant by that?
Rephrase, I'm sorry, say it again.
Well, with regard to
Mr. McCann.
Yeah.
Mr. McCann, let me save you the trouble. I heard his testimony earlier about the embassy rebates and how there were situations where they actually went directly to the vendors. I've heard all of that. You don't need to go over this again.
Okay, thank you, Judge. I have no further questions, Your Honor.
Okay, thank you. Do we have somebody else lined up for this afternoon?
Your Honor, we have decided that we will only use Ms. Heap from Bond and Company if we need her as a rebuttal witness.
Okay, so at this portion subject to rebuttal, you're resting your case?
That's correct, Your Honor.
Okay, Mr. Miller, you want to get started yet today?
Yes. May I have a moment with my clients, a break with my clients before we start
Certainly,
our case?
certainly.
Am I done? Mike, can I be off the testimony?
Yes, you're all done, Mr. Volwinkle. Thank you.
Thank you. Appreciate the time.
So with the court's permission, I'm gonna go on mute and talk to my clients, okay?
All right, fair enough. I'm going to leave the record open.
For once, I would rather stay here.
I hear you.
I'm just gonna throw that out there.
Your Honor, is Tina Heat still in the waiting room?
I don't know that she ever was. Let me check. Don't see her.
Judge, we had called her and told her that we would let her know, we'd give her a call if she needed to testify.
Oh, okay.
I guess I would have liked to have known that she was called off, but we could call her back in if I wanted to. Okay, so she's not here today. I would like to go forward and I'll put on Justin Jaime.
Okay.
And let me, we are not as fancy. We only have one camera. So let me see if I can get us both in here. Want to try to sit here a little closer. Is that sufficient, Your Honor?
That's sufficient for my purposes. Sir, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
State your full name and then spell your last, please.
Justin Herbert Jaime, Jaime.
Go ahead, Mr. Miller.
Thank you, Your Honor. Mr. Jaime, what's your position today at Michigan Pipe Co?
I am the chair of the board.
And when did you become the chair of the board?
I believe right around June, July of 2016.
And did the issue of coming up with the allocation of rebates from 2016 fall on your shoulders primarily?
Yes.
And did you work with Ms. Tina Heap, your CPA, on coming up with the summaries that have been entered into evidence today?
Yes, I did.
And particularly Exhibit 42, and let me get it up just so we're clear about what we're talking about. This Exhibit 42, is this an exhibit that was compiled by Tina Heap?
It was compiled by Tina Heap off of numbers and calculations that I gave her.
So the information contained in here was created by you, correct?
Correct.
And is the information in here based on you going back to each vendor and getting a breakdown from the vendors?
Yes.
Yes? Yeah. Okay, now, throughout the course of this negotiation with Nate Bullwinkle and Mike Deneen, since they left, you've had numerous summaries. Did you, have you not?
I have.
And the information was kind of trickling in all the way up through maybe spring of 2017. Is that fair?
That is fair.
So you were receiving emails from vendors as late as March of 2017 regarding the calculation for breakdown.
Yes, and it went beyond March as well. I mean, we got our embassy numbers reports for the final 2016 numbers, February, March. And after I would get those, I would contact the vendors, and then, it would take a lot of time after March to get whatever numbers and calculations they were going to do.
So finally, the summary that was done in 2018, is that inclusive of all the information you had available to you ultimately?
Yes, I would believe so.
Can you tell me what a bogey rebate is? Well, first of all, let me back it up. Did you have bogey rebates before embassy?
We may have had something similar with some vendors, but I don't think they were ever classified or called bogey rebates.
I think the testimony of Mr. Deneen was that you added the silent and bogey with the embassy contract. Is that fair?
That could be a fair assessment.
So what I believe the testimony is that at the January meeting, when you as a board approved the empathy contract, you also kind of had an understanding amongst yourselves that you were going to continue to pay the rebates like you used to.
Judge, I'm going to object to the leading question.
It was leading. Rephrase your question, Counselor.
Okay, did you enter into an agreement or understanding that you know of in January of 2015 when you approved the embassy contract?
With embassy?
With the other shareholders?
There was no contract that was entered into.
Did you discuss how at the January 2015 meeting how you were going to divide up the rebates?
There might have been discussion about, how to do it, but there was no decisions made.
Now, historically, the rebates were paid according to the individual contracts with each vendor, correct?
Can you repeat that?
Okay. Before embassy, how were rebates calculated?
There was a few different ways that we calculated rebates. One of them would be, we take a certain percentage of purchases, a multiplier for that, a base rebate amount, and multiply that times the purchases to get a total rebate amount. And that could have been for individual companies, shareholders, or it could have been as a whole.
And did you have a different rebate agreement with each different vendor?
Yes.
And how were these rebates paid? What were the various methods? Were they monthly, yearly, quarterly?
They were mostly, I would say, annually paid. There were a few that did quarterly. And there were a couple that gave one check to Michigan Pipe Co. and there were others that gave checks to individual shareholders.
Did any of the, prior to embassy, did any of your vendor rebate agreements include secret, silent rebates?
They did not.
And none of them included something that was at least called bogey rebates, did they?
They did not.
Okay. So if we are going to apply historically, it was basically based on purchases. Let me back this up. Mr. Bowinkle testified that when he purchased pipe, he had a good idea of what that percentage that he was entitled to would be historically prior to the embassy. Do you have any reason to disagree with that?
No, I mean, if it was just pipe, usually those rebates were pretty straightforward. But if it was other material that we bought, there was lots of different structures and rebate programs that we had that did end up getting more complicated. That it might be harder to figure out. But on the far as pipe, yeah, I would agree.
The rebate relationship between the vendors and Michigan Pipe Co. was direct, and so you had a knowledge with each vendor of what that rebate was anticipated for that year. True? I'm asking you the question. So before embassy, Michigan Pipe Co. had the direct relationship negotiating rebates with vendors, correct?
Yes.
Okay. After embassy, and you didn't take over this until after June, but after embassy, who negotiated the rebates with each of the vendors?
The vendors that were a part of embassy, the embassy group had a vendor committee that would negotiate those rebates out.
Okay, now embassy had shareholders similar to Michigan Pipe Co. across this country, did they not?
Correct.
And Was there anyone from Michigan Pipe Co. on that committee? Just out of curiosity.
Yes.
Who was on that committee?
Mike Deneen was.
Okay. So he was a representative that helped Embassy negotiate the rebates.
Correct.
So after Embassy came on board, you still had the quarterly and the annual and sometimes monthly rebates that Embassy would pay, correct?
Correct.
So the bogey and the silent rebates were not historical rebates. They were brand new rebates that never occurred until the Embassy contract. Is that true?
You're talking about different types of
Well,
rebates.
I'm talking about bogey and silent specifically that did not occur with your vendors beforehand. Those were not custom and practice. They were brand new rebates that Embassy had.
They were a brand new type of rebates for Michigan Pipe Co.
Okay. And when the bogey was paid, was that based on sales across at Michigan Pipe Co. or was that based on purchases, across the country?
That was based on purchases for all the shareholders of the Embassy.
So you really have no idea when you're making a purchase whether or not you're going to get a bogey or not, because you don't really understand, you don't have the information how bogeys are calculated by Embassy, do you?
That's correct.
I want to I think that if I did this already, did we talk about Exhibit 42 being the latest and greatest?
We did.
And then were you here during a deposition testimony where we were talking about Exhibit 20 with a summary that was attached that they got from a subpoena to Tina Heap that was attached to a letter that she wrote to Tom Basil?
Yes.
Did you prepare that summary?
This was the one where it was page 5,
Yes.
page 6. Yes, I did.
And was that based on calculations that you received from and breakdowns from the vendors?
Yes, it was. But at the time, the communication between Tina and I had a lot of requests out to all of our vendors that were part of this to try and break it down, and there were multiple communications back and forth with Tina. I'm not sure in what order that was that I gave it to her, or how far complete that breakdown was at that point.
I believe you testified a minute ago that you were still receiving emails after March of 2017.
Correct.
So the letter that Tina Heap had sent to Tom Basil was dated February 2017. So the information that you had, let me just ask this, and I'll go, then I'll leave it. The information you had when you prepared the information for Exhibit 42 was more complete than the information you had when you completed page 6 of Exhibit 20.
I'm going to object, Your Honor, to the leading. I don't understand why I can't just ask him the question.
I don't either. It's a valid objection. Mr. Miller, just about every question you've asked has been a leading question.
Okay,
Mr.
and I appreciate that, Your Honor. I will do better, and I apologize. So of all the summaries that you did, which one is based on the most complete vendor information?
I would say the exhibit number 42, the one on the screen.
Okay. Have you had a chance to look, and I'll pull it up.
Before you leave this, I want to ask Mr. Jaime a question. Mr. Jaime, are silent and bogey rebates included at all in Exhibit 42?
The silent rebate, yes, they are.
Thank you.
Okay, and just so that the court's not misled, I don't think they're included in the column for Lansing and Clinton. Would you explain how they're included? I want to make sure we're not misleading the court.
So the silent and bogey rebates are included. You can't see it here, but it's in the column. It's under Michigan Pipe Co. You scroll up for that. I believe it's 65, 335, 45.
Oh, I see.
This column here.
I see. They're on this list under Pipeco, but they're not allocated among the individual shareholders. Is that what you're saying?
Yeah.
Okay, thank you.
Yep.
That's all the questions I have right now, Your Honor. I would like to, if this court would be willing to allow me to ask a couple questions of Tina Heat in the morning, and then I will be resting. If that is okay with the court.
That's fine with me. Mr. McCann?
No objection, Your Honor.
You have some questions right now for Mr. Jaime?
Oh, sure. Okay, Mr. Jaime, you indicate that you have been the chair since June of 2016, correct?
Correct, around that time, June or July.
Okay. And I believe you indicated that there had been a form of bogey and silent rebates in the past historically, but they might have been called something else by other vendors. Is that fair?
Yeah, maybe like a tier rebate or something. Something similar, but not the same.
Something with a different name, but that might represent a targeted amount of pipe that you would achieve in order to earn it?
Yeah, I mean, there could have been.
Yeah. You're not sure?
Yeah.
Okay.
It's not uncommon for a rebate structure to have something like that, but I'm not sure if we had those structures with the vendors beforehand.
All right. At the January of 2015 meeting, you said there might have been discussions about how to divide rebates. At that meeting, that's when the board voted Embassy in, correct? January 8th of 2015?
That's when we voted to be members of Embassy?
Correct.
Yes.
Okay. And Mike Deneen was elected as the representative to sign on behalf of the board. Is that correct?
That is what we agreed, yes.
Was there a generalized knowledge about what an individual Michigan Pipe and Valves rebates would be? I know you said that you specifically didn't know, but was there a generalized knowledge about what your approximate rebates would be based upon your sales?
I would say no. I mean, typically you could look at a year and get the total amount of rebates from the year before, and you have a percentage of your sales, but I would say that probably differed year by year. So I would say no, you couldn't generally.
Differed year by year, but within a reasonable range, I would assume, right? You would at least be able to make a prediction based on what you had historically sold or what your purchases were compared to what they would be in a next given year.
Well, so, depending on the vendor is the rebate program that you would set up. So if we buy from one vendor one year a substantial amount more than we would another vendor, which happens year to year, then the amount of rebate that we would get would differ significantly. So I would still say that we wouldn't know.
Okay, were there bogey and silent rebates in 2015?
You mean did we have a rebate program or structure that those were a part of?
Yeah, well, yeah, in 2015.
There was a rebate program.
I'm sorry, after Embassy.
Yes.
Okay. And some of those rebates were distributed, correct?
For bogeys. Are you
Bogey
talking
and
about
silent, bogey or silent rebates?
Not in 2015, they were not.
Were they distributed after that?
Yes.
In what, 2016?
I don't believe so.
Okay. Bogey rebates from there would have been some earned in 2015, correct?
Yes.
And when were those distributed?
I can't recall off the top of my head. I believe we made distributions. I don't know if those were distributed or not. I think maybe after. No, there was no distributions of the rebates, or not the rebates, but for the silent and bogey rebates.
Ones that were earned from 2015, none of those were distributed?
Correct. As part of the Exhibit 42, you can see that that was allocated to Michigan Pipe Co. It wasn't distributed to any yards.
Isn't that for 16?
Those are. Oh, that's correct. Yes.
Okay, so 15 I'm talking about. Are you testifying that none of those were distributed?
I can't recall if they were or not. I can't recall if they were or not. We distributed rebates for 15 for the first 3 quarters, and partial rebates for 4th quarter. And as far as the bogey rebates, I am not sure if those were calculated or not, or distributed or not. The silent rebate for 15 was kept in corporate office, but I'm not sure about the as per our agreement with the silent rebate, but I can't recall on the bogeys.
So you show $65,000 allocated to Michigan Pipe Company for bogey rebates and silent rebates, correct?
Correct. That 65 doesn't include all of the bogey rebates.
Oh, that's for a certain quarter, right? I can't see the whole page, so.
Well, no, I mean, bogey rebates are for annual. They're not for quarter. We would have got those in 4th quarter.
I see.
But that amount was totaled because when I received breakdowns from our vendors, that amount was not included in their breakdowns. So I didn't calculate that out as far as dividing that up between the branches.
Okay, but those normally would be distributed to the branches, correct?
If there was a breakdown for it from our vendors, I'm assuming that's the way that that Linda would have done it before I took over.
Okay, and if there wasn't a breakdown, Linda testified that she would use the accounts payable method. So I assume they would have been distributed one way or another, correct?
Well, we didn't really have a way to do it for bogeys by the time she left. So, I mean, we would have got that first bogey report from Embassy in February, March of 2016. And she had not done that yet before she had left.
At the time, you didn't have a formula to distribute it, that you we're comfortable with relying on.
Correct.
I have no further questions, Your Honor.
So I want to make sure I understand. I thought I did, and now I'm confused. So, Mr. Jaime, if I look at Exhibit 42, the column for pipe company, fourth quarter 2015 embassy, $24,715.69. That number represents either bogey or silent or both received from embassy during the fourth quarter of 2015, and it was allocated to Michigan Pipe Company because you weren't sure how you were going to distribute that among the shareholders?
Correct.
Same column, first quarter 2016, amount allocated to pipe company, $2,446.29. Again, it's either bogey or silent or a combination of both. Allocated to pipe company because you didn't know how to allocate it to anyone else.
Correct. That would have been, it would have been from information that I gathered from the vendors. If I didn't have enough information to break it down, to be able to distribute it, instead of using the AP method, which is not very accurate, is I allocated that and put it into the Pipeco column.
Right.
Yes.
And similarly, the last item in that column, fourth quarter 2016, $65,335.46. Again, either or both bogey and silent, allocated to pipe company because you didn't know how to allocate it to anyone else at that point.
Correct.
So if I add up those three numbers, that would equal the total amount received from embassy that would be classified as bogey and or silent through the end of that time period.
Go out again.
Yeah.
Excuse me, Your Honor, this happens a couple times. It'll come back in a minute. There we go. Okay. We lost your question.
That's fine. I'll ask it again. So from what was received for the fourth quarter 2015 from embassy through the fourth quarter 2016, in other words, those three items that are in the pipe company column, those three numbers total the total amount you received from embassy for that time period that embassy classified either as silent or bogey.
Yes, they definitely. So all the ones I couldn't, the bogeys that I was not able to break down for lack of information from our vendors, plus the silent rebates, are all.
So there were some bogeys that you were able to allocate,
Correct.
and those would be included in the other columns.
Correct.
Was there any bogey that you could allocate that's been allocated in this form to either Flint or Lansing?
I do not think so. For 2016, I don't believe there was any. For 2015, I believe we did. If there was anything to distribute then, or any information that I had to break down that bogey rebate.
So just a broader question. When the shareholders got together and agreed to do a deal with embassy, the understanding was that the the 5 shareholders would share in the whatever rebates came from Embassy based upon their contribution to the purchases that generated those rebates. True?
True, there was that was, yes. But, and on top of it, there was also an agreement with the silent rebates that they were to be kept in Pipeco because there was no way of breaking it down.
And I think I remember seeing that in the minutes. All right, any follow-up questions based on mine, gentlemen?
No, but I just have a couple follow-up questions, Your Honor, based on both yours and not really yours, but based on the clients, but they're short.
Go ahead.
But I think you just mentioned it. You said there was an agreement regarding silent rebate, and what was that agreement?
The agreement was because we were unable to break down the rebate because there wasn't any information that we could gather from the vendors or from Embassy by design, that we would keep that in Pipeco to help pay for our annual employee parties.
Okay. And I believe you testified with me that there was no agreement other than at the January meeting to
Object to the leading question, Your Honor.
What?
Yeah, direct exam, no leading questions.
Yeah, okay, well, I haven't asked the question yet, but and according to the judge's questions, you suggested there was an agreement, and so I just wanted to clarify because it's kind of the point. What was the understanding at the January meeting regarding the rebates?
Regarding the silent rebates?
Well, anything. You had a meeting in January 15. What actually was determined at that meeting?
To the best of my knowledge, what was agreed upon was that we would join Embassy. We decided and voted on the silent rebates, or we decided on the silent rebates. And as far as Embassy goes, those were the only things that we really had a decision about.
Now, there was an expectation. I just want to be honest. There was an expectation that you were going to. Was there an expectation that all the shareholders would share in the rebates?
Yes.
Okay. Did you anticipate? Was there a buy-sell in play at Michigan Pipeco concerning what would you do if a shareholder left?
We didn't have a buy-sell agreement.
Okay. So there was no contemplation at January what you're going to do if one of the shareholders decides to leave.
Correct.
Okay. The last thing I'm going to ask you about is the management fee that we've been talking about. I'm not going to bother putting it up. Was that a contract? I'm going to withdraw that. I don't have any further questions.
Anything further, Mr. McCann?
Just real briefly, Your Honor, we're going to pull up Exhibit 8.
Exhibit what?
Exhibit number 8.
Okay, something's happening here. Oh, you're pulling it up now. You got a guy now?
I got a guy back just now.
Okay.
Can you, let's go to the first page of this, please. Can you identify this for me, Mr. Jaime?
This is the February 20th, 2016 board meeting minutes.
Okay. And can we go to number 3? You see a discussion of the Embassy rebates there in number 3?
I do.
Can you tell me what that says? The first couple of lines, or first 3 lines or 4 lines.
Embassy rebates. Linda gave us the fourth quarter breakdown for the embassy rebates, just with the fourth quarter rebates, the secret rebates, and the bogey rebates. It was decided that the embassy group is worth the money of being in the group. Mike Deneen and Nate are going to contact the companies that we received bogey money from so they can get us a breakdown per branch.
And then it goes on that Linda's also working on getting all of our quarterly rebates broken down, correct?
Yes.
You can bring that back down. I have no further questions, Your Honor.
Okay, looks like this might be a good place to stop. We'll see you back here in the morning. Let me just pull my schedule up real quick. Oops, wrong date. Let's try that again. Yeah, we're good at 8:30. I've got one matter that I'll need to take a break and address, but otherwise the full morning is yours, and then we'll figure out then how much more time we're going to need to finish up. Any idea from either of you?
Yeah, Your Honor. I'm going to have maybe a couple questions. Can you eat? Maybe a couple questions with Mr. Brugger, and maybe a couple questions with Teresa Jaime. But it's going to be maybe 5. Attorney says short, but it's going to be very short.
So we could easily finish tomorrow?
Yes.
I believe so.
Oh, wonderful. Good news. All right, gentlemen, have a good evening. We'll see you at 8:30.
Thank you, Your Honor.